Mr. Chairman, I am through my examination of the witnesses. I would point out that Congressman Frank Wolf is here, and it has some urgency about...
No, I'm okay. Yeah. I'm at a meter, but I just had some hard work.
Mr. Chair, again, I think as a personal privilege, we should reserve questioning until after Mr. Congressman Wolf comes.
Okay, we are going to change our proceedings a bit. The original plan called for us to question the witnesses at this point. Since Congressman Wolf is here, we will, at this point, listen to the testimony that Congressman Wolf has to put into the record. So, gentlemen, please stick around. Congressman Wolf, would you please move to the table? Okay. We are honored to have with us today Representative Frank Wolf of Virginia. Thank you for carving out time in your busy schedule to join us.
Thank you very much. Mr. Chairman and members of the Commission, I want to personally thank you for the opportunity to testify today. I have several documents I'd like to submit for the Commission's record as part of my testimony. As a former chairman and current ranking member on the House Commerce, Justice, Science, Appropriations Subcommittee with jurisdiction over the U.S. Commission on Civil Rights, I'm very familiar with the Commission's essential role in assuring the integrity of our nation's civil and voting rights laws. As you know, the Commission has an important special statutory responsibility to investigate voting rights deprivation and make appraisals of federal policies to enforce federal voting rights law. Congress instilled this independent oversight responsibility on the Commission in statute, where it said all federal agencies shall fully cooperate with the Commission to the end that it may effectively carry out its functions and duties. And I'd remind the Attorney General that this includes the Commission's authority to subpoena witnesses. I appreciate your efforts to investigate this unexplained dismissal of the U.S. versus New Black Panther Party case, which has serious and dangerous consequences for future voter intimidation enforcement. I am a strong supporter of the Voting Rights Act, which is why I was so deeply troubled by Justice's questionable dismissal of such an important voter intimidation case in Philadelphia, where I grew up and my father was a Philadelphia policeman. My commitment to voting rights is unquestioned. In 1981, I was the only member, Republican or Democrat, of the Virginia delegation in the House of Representatives to vote for the Voting Rights Act, and was harshly criticized then by the editorial page of the Richmond Times-Dispatch, the state's leading newspaper. I was again criticized in a number of editorials in 2006 by another newspaper in my district when I supported the Act's reauthorization. From the beginning, I have asked the question, why did the department dismiss this serious case? Looking at the facts, if this is not clear a case of voter intimidation, I do not know what is. The public can view video of the incident as well as other examples of the party's intimidation in a clip from National Geographic Channel documentary entitled, quote, "Coming to a Polling Place Near You," posted on the website at www.electionjournal.org. My concerns have only been compounded over the last year in light of the Department's obstruction of oversight investigations by the Congress and this Commission. The action of the Attorney General to allow the Department's obstruction of this Commission's investigation are puzzling. I believe he is undermining, in some respects, the federal oversight of the Justice Department. For nearly a year, I have been urging the Department to release all the documents surrounding this case and to make a genuine attempt to answer the questions asked by members of Congress and by this Commission. The requests have been rebuffed at each turn. Earlier this year, I introduced a resolution of inquiry that would have compelled the Attorney General to release all requested documents to the Congress. It was defeated in a party line vote in the House Judiciary Committee. I've urged the Department's Inspector General, Glenn Fine, on multiple occasions to open an investigation into whether improper political influence contributed to the dismissal of this case. Unfortunately, Mr. Klein continues to maintain that ignorance, which I believe is unacceptable, abdication of his responsibility, because the IG's office is supposed to look at these things in the Justice Department, and we fully fund the IG to give him the resources to do so. This defines lack of action, I believe, deserves the scrutiny of the Council of Inspectors Generals on Integrity Efficiency, called the CIGI, and I will be requesting that the Council look into its failure with regard to this matter. What should be a bipartisan support for robust voting rights enforcement has become, I think, a bad example of the types of partisan obstruction that undermine our nation's civil rights laws. Last summer, the Washington Times, and it's been somewhat troubling, some papers have covered this and others have just almost ignored it. The Philadelphia Inquirer, the last remaining paper, major paper in the city of Philadelphia. I used to deliver the Philadelphia Bulletin. But in Philadelphia, nearly everyone reads the Inquirer. The Inquirer has almost pretended that this has not even taken place. As some of the Washington Times reported that the department's voter intimidation case against the new Black Panther Party was dismissed over the objections of career attorneys. And again, all of this has been initiated by career people. I used to work for the Department of Interior before I served in Congress, but all of the activity has all been with regard to the decisions on moving ahead have been made by career people. And this was dismissed over the objections of the career attorneys on the trial team, as well as the chief of the division's appellate division. According to the appellate division memos first disclosed in the Times article, appellate chief Diana K. Flynn said, quote, "The appropriate action was to pursue the default judgment," end of quote, and that justice had made, quote, "a reasonable argument in favor of default relief against all defendants," end of quote. Flynn's opinion was shared by a second appellate division official, Marie K. McElderry, who stated, quote, "The government's predominant interest in preventing intimidation, threats, and coercion against voters or persons urging or aiding persons to vote or to attempt to vote," end of quote. Given these troubling disclosures, I have repeatedly called on the Attorney General to refile the civil suit and to allow a ruling from the judge based on the merits of the case, not political expediency, but solely on the merits of the case. The career trial team should be allowed to bring the case again, per the guidance I obtained from the Congressional Research Service's American Law Division in its July 30 memo, quote, to allow our nation's justice system to work as it was intended, impartially and without bias. Sources within the department stated that the Associate Attorney General Thomas Pirelli, a political appointee, in conjunction with the Acting Assistant Attorney General for Civil Rights, Ms. Loretta King, and her deputy, Mr. Stephen Rosenbaum, overruled the career attorneys in the voting rights section. Earlier this week, the department finally acknowledged that the Attorney General was made aware on multiple occasions of the steps being taken to dismiss this case. Why would the department's political leadership overrule the unanimous opinion of the career attorneys on the trial team and the appellate division? Why would the department's political leadership not seek a default judgment to secure the maximum enforcement of the Voting Rights Act? The Justice Department is responsible for the vigorous enforcement of civil rights statutes. It is my understanding that the career attorneys who originally brought this case continue to stand by its merit. These are, again, career people who have dedicated their life and their career and have been very courageous to be pushing this ahead and knowing that their careers could be impacted by the political people who run the department. The politicization of the Justice Department against career employees is absolutely wrong, and both the Congress and the Commission have to get to the bottom of this. I want to leave you with one last thought. It is my understanding that the career voting section chief, Chris Coates, offered a vigorous defense of the new Black Panther Party case at his going away luncheon earlier this year.